Was your court reporter coming back today?
I just assumed she would be here after the announcement from yesterday. I didn't receive any indication that she wouldn't, but I didn't receive any other indication that she would. In other words, I haven't heard anything this morning.
Okay. I'm fine proceeding without the court reporter.
Yeah,
I
I
just
just wanted
walked
to
in
make
on,
sure we weren't waiting for someone.
yeah, I just walked in on the court reporter. What's going on?
Your Honor, I was trying to confirm if we were waiting on their court reporter because there was not one logged in.
Yeah, I think you're gonna, I don't know. I mean, I think this is for both of you. I don't think you're gonna be able to submit for Court of Appeal purposes, an incomplete record. It's incomplete. You got missing testimonies. I don't like it. I don't feel comfortable with that. But I guess we'll deal with that issue when it's right. But you got to have a court reporter that's going to cover all things. You can't have half a day missing unless you all come to a resolution. I don't know. But anyway, that makes me uneasy. But anyway, so we stopped last night with the finishing up the closing for the respondent. So now we're gonna move to the petitioner closing. You may begin.
Sure. So, first, good morning, Your Honor.
Good
Um,
morning.
and may it please the court. I do want to start by saying thank you for taking the time to pay attention to the details of this trial. But I also want to caution the court to not get so bogged down in the details of this trial, because I think that a lot of these details are a smokescreen. You see, the reality is this case is quite simple. Um, all we have to show is that there has been a change from the time that this divorce decree was entered until now that has materially affected the welfare of this child, and that the child's best interests are going to be served by a change of custody. Well, from the time that this divorce decree has been entered until now, we have been able to show several things. One, we have been able to show that mom has been medically neglectful of this child. We have shown multiple times that mom sends this child with blisters on her feet. We have shown multiple times that mom sends this child with fungus on her feet. We have shown multiple times that the escalation of the alienation, that is something that could not have existed at the time of the parties' divorce because the child wasn't in school. Child was an infant. So that is a circumstance that could not have existed at the time of the child's or at the parties' divorce. That is a new circumstance. That is something that they could not have known. That in and of itself is new. He could not have known that he would be excluded from communications with the school, would be excluded from communications with the daycare. He couldn't have known that. So that's new in and of itself. We have shown that he has been precluded from conversations with the child on multiple occasions, that he has had his visitation denied. All of this, I'm going to go through case law in a moment, but I'm just giving you an overview of the land, the lay of the land here. All of this, the Court of Appeals has held, and the Georgia Supreme Court has held, to be a material change of circumstance. And we have been able to show a tangible link that this affects the welfare of the minor child. And then we did part A. We gave you your change of circumstance. And now part B, the best interest. We didn't rely on a layman. We didn't just get up here and put our client up and then, ask him a bunch of questions like, hey, with your 48 hours a month that you get to see your child, you tell us why you think it's in your child's best interest, why you should have primary custody. We got a guardian, and at the urging of the guardian, we got a forensic evaluator, both of whom testified that it would be best for this child to be in dad's primary custody. Not only did they both testify that at the onset of the trial, but the guardian, after investigating mom's claims of dad's physical abuse and after listening to this recording that was submitted into evidence, the guardian maintained that after all this, like, yeah, could everyone stand to cool off? Absolutely. And I don't disagree, Your Honor. I really don't. But still, this child's best interest, which is what you, Your Honor, are supposed to be looking at, that is what is best served by this child being in the primary custody of her father. So we're going to look at some case law. We're going to look at Frank v. Lake, 266 Georgia Court of Appeals, 60. This is a 2004 case. This held that medical neglect adversely affecting at least one child is sufficient to support a modification action. So let's, the fact pattern in that case is pretty similar to what we're looking at here. Our client took the child to the doctor at least 3 times, sending her home with medicine twice. That was for a fungal infection. But what we're also looking at is blisters from 2 small shoes and no socks. The testimony from the guardian ad litem the first time was that the child was not allowed to wear socks. And, they're talking about this feet condition is hereditary. All right, that may be true, but blisters are not. Blisters are certainly not hereditary. And even so, a hereditary foot condition may be such a thing, but you can cure blisters by simply wearing socks. But the testimony showed that the fact that dad sent this child home with socks was so offensive to mom and Mr. King that thereafter the child was forbidden from wearing socks. So now what happens? She comes with open blisters. Plaintiff's Exhibit E, Plaintiff's Exhibit G. These are blisters. These are not, what did mom call it? Oh, a stubbed toe. She said she stubbed her toe. That's what it was. That's not what that was. Those were blisters. Clear as day. The court could take judicial notice those were blisters. And that is what happens when you wear shoes that are too small. I mean, that happened on multiple occasions. Look at the soiled shoes from Plaintiff's Exhibit F. Like, this is the condition that this child is returned to dad in regularly, not just 1 time, 2 times, 3 times. And, the issue that I take with the way that the respondents presented their case is they say, okay, well, dad is constantly taking pictures, constantly taking pictures, constantly taking pictures. And then they turn around and say, well, where are the pictures? Where are the pictures? Where are the pictures? Like, when he says, hey, you sent this child in 2T, 3T underwear when she's 6 years old. Do you want me to throw this in the trash? Mom says, well, I don't know that he sent her, or I don't know that she was in 2, 3, or 3T underwear because I didn't see any pictures. That was her testimony. So what? He's supposed to take pictures every time. But when he does, she says, well, why are you taking pictures of my child in underwear? Or why are you taking pictures of my child's underwear? You're sexualizing her. I mean, he's damned if he does and he's damned if he doesn't. And that is the heart of the problem in this case. Dad cannot communicate with mom in any way. If he communicates without the pictures, he's punished for it. If he communicates with the pictures, he's punished for it. There is no winning. So moving on, and then, there's the blisters. There's the blisters for cooking from herself. An expert in child developmental psychology said that child is too young for the level of cooking that she was doing. She is too young for the level of independence mom was having her do. She is too young to be bathing herself independently. She is too young to be cooking independently. And it didn't stop. Mom's excuse is that, oh, that wasn't a burn, that was a callus from rock climbing. Okay, that's a really bad excuse, because you mean to tell me that after your child broke her arm playing at the playground, you were letting her run around the playground rock climbing with a broken arm? Because that's also something you're not supposed to do. So which is it? She either burned herself again, or she developed another callus after breaking her arm because she was rock climbing with a broken arm. Which is it? You can't have it both ways, or neither way. So which is it? Either way, that is medically neglectful. And that is what Frank v. Lake says. If one parent is not taking proper care of the child, that is a substantial change in circumstance. And the facts of this case support it. Gibson v. Pierce. This is 176 Georgia Court of Appeals 287. This case held that where the mother was awarded primary custody of the minor child and subsequently allowed her fiance to move in with her and the minor child, the court had the authority to award a modification in custody based on the substantial change of circumstance not presently existing or disclosed at the time of the original custody determination was made. We spent.
I'm sorry, 1 second, real quick. I hate to do this for you.
No, it's okay.
I was trying to send you a text. Can you bring, as the cases are quoted, if you'll bring those to me, with the highlights, just bring them over, don't wait. And this is 266, the last one's 266, Georgia Court of Appeals 60. Thanks. You may continue.
Sure. So what's interesting in Gibson is that they talk about not disclosed at the time of the original custody determination. And we spent, I mean, in my opinion, way too long talking about who knew who and who knew what at the time that the parties entered the decree. And by mom's own admission, They just didn't disclose that kind of information. But something became abundantly clear because they kept mentioning Alexa. Dad had been with Alexa at the time of the party separation. Dad is now presently married to Alexa. He's remained married to Alexa. Mom was with Mr. King either at the separation or shortly thereafter and was with Melody. Mom is no longer with Melody, but in the time since the separation till present, she has lived in 4 different places and with at least 6 different people. He cannot consent to people living in the home that he did not know existed at the time of the separation. He simply cannot consent to it. So everyone wants to talk about the polyamory. The polyamory is not the issue, and making it about the polyamory is the red herring. Dad's issue is not her lifestyle, and it's not about the fact that she has multiple partners. That's not the problem. And he even said that in the text message. You do you. You have whatever partners you have fun, live your life, live it to the fullest. But don't bring that around our kid because the instability, that is the problem. And Dr. Levy testified to that because this child forms attachments. And having them come into the house, reside in the house, and then leave, that's the issue. It's not the fact that mom is polyamorous. It's the fact that mom's relationships are not lasting, and then these people are coming in and leaving again. That's the issue. It would be the same thing as if she were monogamous, but having these multiple partners, boyfriend this month, boyfriend next month, girlfriend this month, girlfriend next month. That's the malfunction. And that is what is materially harming this child.
Wait a minute. I thought Melanie left during the middle before we even had this hearing, so he wouldn't have even known that she had left. I thought Melanie left while we were in the process. Like, he didn't start his application because of instability of relationships, because the instability didn't occur until during the hearing, like during the process.
No, it was because
So
Melody was going in and out.
Has to be the issue.
Melody was going in and out. Melody and the testimony was that Melody and Mr. King were having issues and she was moving in and out. And during the proceedings rather, is when she finally moved out for good. And that is when Dr. Levy did her examination and said that her moving out for good had really affected Ivy.
Okay, maybe okay.
Because so if Your Honor will recall,
I thought his position was the polyamorous relationship and the effect on the child, which is the reason why I thought Dr. Levy was brought in. And my questions to Dr. Levy when I was trying to figure this out was, hey, is this causing an effect on this child? And her position was no.
No, and if Your Honor will recall, the issue is when
I'm sorry, I apologize. I'm gonna stop. I'm gonna let you finish your closing. It's just sometimes people will say something in closing that's inconsistent with my notes and it just throws me off.
Sure.
I just want to make sure I'm on the right page. Okay, so go ahead. I don't want to throw you off. Go ahead and finish your closing.
No, it's okay. I love this. This is like being in the Court of Appeals. No, so one of the concerns that Dad had raised is during the time that Melody was coming in and out, the child had, in one of the other residences, she had been removed from her room. So she was sleeping in a hallway. And that was his issue, was the inconsistencies. And so that was what first started this whole thing. That she no longer had a room. Now she has a room and she has had a consistent room, which the guardian ad litem had testified to. But that was what first started all of this, was the inconsistency in the child's bedroom and the fact that Melody was in and out. Now Melody's been out for a while. To answer that question. And this has been a long time, so I understand why there's been a lot of confusion because there's a lot of facts and people to keep straight. But moving on. So anyways, he cannot consent, or he can consent to her having multiple partners, although his consent has no relevance to her dating life. It has to be what he consented to was that she keep it, she tried to keep Ivy's best interest at heart, and she tried to keep that separate from Ivy. And I think that this is something that all parents consent to. We say, hey, you as the other parent, you do what is best, you do what you're going to do, but don't make decisions that are going to have a negative impact on our child. Meaning, don't bring someone into our kid's life that's just going to be out the next day. And that is, that's unanimous among parents. And so to say that, like, oh, well, he consented to her having this polyamorous lifestyle, that's not the issue. Like, Mom seems to be blaming Mr. Maynard for the introduction of the polyamorous lifestyle, but this child was not even conceived at that time. And she left when at 6 weeks pregnant by her own testimony. So at best, she did not know and knows now. At worst, she knew and kept it from him, meaning at best, she did not know at the time that, I'm so sorry, I skipped a line in my closing. The other issue is that she began this relationship with Mr. King and then kept from Mr. Maynard the criminal nature of his background. So it's not necessarily Mr. Maynard's issue with Mr. King is not necessarily the criminal nature, although that is alarming. It's the secrecy around it. And you heard testimony regarding that from the guardian ad litem. The guardian ad litem was reported one thing, the interrogatories said another thing, and the court heard a third different outcome. And Your Honor, her testimony to you, and I hope you were paying close attention to it because it is indicative of what this process has been like with her through discovery. Well, I can't remember. I know it wasn't sexual. I don't know. We don't really talk about it like that. It was so evasive and cagey and dodgy. And that is how she has been this whole time. That is how she has been with Mr. Maynard. He could not get a straight answer from her. And the guardian ad litem flat out said on her intake form, she said that he had served time for murder. Why did it take a background check? Why did it take, the parents having to pay this money for an investigator and all this kind of stuff to figure out that this man had done time for murder? Why did it take all of that? You couldn't even get a straight answer from him. You had to ask him how many people died, Mr. King. You had to do that. So at best, she did not know when she started that relationship, but she knew when she did her intake with the guardian ad litem, and she lied to you. She lied to you. She looked you in the face and she lied to you and said, well, I don't really know. It's been so long. I know it's not sexual, whatever. She tried to avoid the question. That is the issue. It's not necessarily the criminal nature. It's how evasive and secretive she is. And there is case law on point to that. And Todd B. Casciano, I think that this is an Italian name, so I apologize for butchering that. That is 256 Georgia Court of Appeals 631, 2002 case. So this is one that's kind of speaking to what I was talking about before. This is where the appellate court held that where a mother began a sexual relationship with a boyfriend and that sexual relationship resulted in concerning behaviors for the minor child, that was a material change of circumstance that warranted a change in custody. This is exactly what Dr. Levy testified to. It's not that the polyamorous relationship itself caused a problem for the child. It is the circumstances around it. It is that the child formed an attachment to Melody and then she left. It is that the child was confused. Why is mommy kissing Melody and then Mr. King? It is that the child had to sleep in a hallway because she lost her bedroom because first Melody and Terrence were sleeping in the main bedroom, but then they had a fight and they were sleeping in the other room. That is the issue. It's the instability within the household. She can't even Zoom with her grandparents with her camera on. That's a problem, Your Honor. That is a problem. What is she so afraid of that her own parents can't look at the inside of her house? This speaks directly to Dr. Levy's concern. Ievi's mental and behavioral health is absolutely a concern as a direct result of the environment in Miss King's home. The court can constitute the development of this romantic relationship and the change in this home, these people coming in, T and Monique and all these other people, as a material change when all this cohabitation and this disruption is affecting this minor child. And it has. It has. We had two experts say that this is affecting this minor child. These aren't lay people. These are two experts. You have a 1993 expert in the form of the guardian ad litem, and you have a forensic child psychology expert saying that this is affecting this minor child.
How did they say?
Dr. Levy said specifically that the child is nervous about communicating outside of the mother's home, and that we know that this is likely going to lead to an anxiety disorder. And Tori said the same thing, based on her own experience, that this is likely to lead to an anxiety disorder.
I'm going to object to incorrect testimony. I'm just objecting to the court. That was never said.
Tori said that Ievi being nervous about communicating outside of her mother's home, she said, we know this is likely going to lead to an anxiety disorder based on our experience. That was Tori's testimony.
That is nowhere in her recommendation.
I thank you. Thank you so much, Ms. Hart. Go ahead and finish. You may continue.
Okay. And then what Levy had said was that she thinks her mom's partners are her friends, but she also mourned Melody's daughter when she moved out. So she clearly thinks of these people as closer than friends. And then she knows that Terrence is not her dad, but she thinks she should call him dad. She calls her mom heir, which she got from some other older adult in the home. And then Dr. Levy also called, she specifically said that mom's treatment of the child was neglectful. She used the word neglectful. So, this is all like the cohabitation and this kind of commune-esque circumstance in the home. This is what I'm talking about when I say like this all speaks to Dr. Levy's concerns. Dr. Levy was very, very, very quick to raise the flag and say, hey, there's something going on here. Like, Tori, you need to get involved, because there is an issue here. When you have a child in 2-3 T3 underwear, when she is 6 years old and she is forced to bathe and cook for herself, and Dr. Levy, again, an expert in child developmental psychology, is saying, hey, this is not an age-appropriate behavior. She is struggling, and she is going to her dad's house with poop in her underwear because she has not been taught to wipe herself appropriately, and she burns herself on the air fryer, and she's forced to be too independent too quickly. That is an issue. That is exactly the concern, because she is not getting normal parent-child interaction in this home. What she's getting is, she's living in this cohabitation. She's very confused about the interactions with all these adults. So then, and that's Dr. Levy. Dr. Levy saying she just doesn't know who is who in that house. All right, Jones v. Kimes. This is 287 Georgia Court of Appeals, 526. This is a very simple case. Appellate court held that repeated denial of visitation constitute a material change in circumstance supporting changing custody. The issue with these parties is that they really like to play gotcha. Mom likes to play gotcha. She plays gotcha with a fall break. And unfortunately for dad, mom is the one in control because mom's got primary custody. So mom doesn't send that text and say, hey, it's my fall break. I'm not going to be at the exchange location, so don't bother going there. And mom doesn't send that text that says, hey, it's your fall break. I'm on my way. See you at 7:30. She doesn't do any of that. She plays gotcha. And instead of being like, hey, I'm at the exchange location, are you on your way, running late or anything like that? Or I'll just meet you at 9:30, or I'll just meet you tomorrow morning at 8:30. She punishes him. Notice she makes him wait one whole day. You can pick her up tomorrow at 7:30. She punishes him tomorrow at 7:30. That is the game that they like to play. That is a denial of his visitation. That is what they do. And that's not the first time. Mom doesn't get to unilaterally play the COVID game and say because dad's household may or may not have had COVID some time ago, that now until they test an infant for COVID, that the child is not going back. That's not mom's decision to make. Dad gets to pick how he runs his household too. And if he was comfortable with the fact that nobody in that household had COVID, he gets to have his parenting time. But mom unilaterally made that decision. And as mom unilaterally makes a lot of decisions. Mom unilaterally decides when dad's phone calls with the child are going to end. Mom unilaterally decided which calendar they were going to follow for fall break, depending on which one was more convenient for her. Mom unilaterally decided what time dad was going to get the child for fall break when dad missed his fall break. Mom unilaterally decides everything. Mom unilaterally takes the child away from dad when it suits her. And, she got up on that stand and she said, to Your Honor, well, that's the purpose of a parenting plan. It's to simplify these things so that we don't have to communicate. That's not what being a primary parent is. Unfortunately, and, Your Honor, this is one of those things that in practice, you have to explain to your client all the time. When you are the primary parent, the onus is on you to communicate with the other party ad nauseum. The onus is on you to keep up with that schedule and make sure that the communication is going. The onus is on you to talk about those awards ceremonies and to get those pictures going and to get that calendar organized. The onus is on you because the onus is on you to always be looking out for your child's best interest, which means making sure that dad has all the information he needs so that if he wants to go to this awards ceremony, he can go. That's what this is. That's what being a primary parent is. And she's dropping the ball all over the place, and she is withholding visitation, and she is withholding the phone calls are visitation. The court ordered phone calls are visitation, and she withholds those too. And there's plenty of testimony as to that. ARP v. Hammonds. This is a case, it's loosely tangentially related, but I'll just give it to you anyways. This is 200 Georgia Court of Appeals 715. This is one where just change of circumstances for either party, where they now have a better capacity, would be a material change of circumstance. At the time that the divorce decree was signed, Mr. Maynard was living on base. He is no longer living on base. He is here. He is married. He's got a stable marriage. He's got a stable house. And that in and of itself, that is a very material change of circumstance. It's one that we kind of briefly addressed, but that is 100% very different from the time that the parties were getting a divorce. Miss Ham talked about how she didn't really know that he was moving here because he stayed with his parents, then he got an apartment or whatever. But now he's got a home. He's got a child. He is married, and he has and if you notice on the Guardian's Matrix, he got the X for stability and mom didn't. And there's a reason for that. His capacity has changed. And if you look at Art V. Hammond's, that is a change of circumstance. And that is actually one that we kind of glossed over in this case, but one that is quite significant because Dad's capacity has changed significantly from the time that the divorce decree was filed till present. Dad is no longer, he's out of the military. He is just here. He is married. He's got his job. He's got his living situation all settled in, and he has this home, and he is ready, willing, and able to take this child full time in a position that he was not at the time that the parties were divorced. Oh my gosh. May I take just 2 seconds to grab a drink of water? Sorry, I don't normally talk this long early in the morning. Moving on. Medley v. Mosley. This is 334 Georgia Court of Appeals 589. This is a case where the appellate court held that the trial court did not abuse its discretion by awarding primary physical custody to the father because the father established that the mother had interfered with visitation in violation of numerous court orders and consent agreements by preventing the father from exercising his visitation, as well as leaving the child with the maternal grandmother while the mother worked instead of allowing the father to take the child. We've already covered that, but I just want to give you another cite. So in regards to the cases that opposing counsel cited, they're distinguishable from this case in a number of ways. Burnham v. Burnham. Why is Burnham quoted so often? Because Burnham stands for the fact that you have to make the finding first. You cannot simply order the change of custody. You have to make the finding first. You have to put in the order, here is your finding, here is what the court is relying on for your new and material change, and here is how it affects the child, and now here is the change of custody. That's what Burnham stands for and why it's such a huge case that is so often quoted and cited. But you look at Dr. Levy's testimony, it's not the polyamory, it's the instability. That is your material change. Mom's relationship instability has affected the child. The guardian ad litem testified to that. That is your threshold finding. Mom has lived, and the guardian testified to this too. Mom has lived at 4 different residences. The child has attended 3 different schools and or daycares. The guardian wasn't really clear on that. And mom has had 6 different people in the house. I mean, this is like, and a partridge in a pear tree. This is an incredible amount of people coming and going, homes moving, schools, friends, all this stuff. And, mom just kind of shrugs it off like, well, Evie's fine. She's resilient. She's fine. She just makes friends everywhere she goes. She's fine. She's fine. She's fine. Well, the experts disagree. Dr. Levy disagrees. She disagrees that this child is fine. She really does. The guardian ad litem disagrees. The guardian ad litem fervently believes that this change of custody needs to occur now. And you have your threshold finding. It is mom's instability, and that is sufficient. It is sufficient because the instability did not exist at the time of the party's decree, because mom had 1 apartment at the time of the party's decree, and now she has had 4. Mom had 2 partners at the time of the party's decree, and now she has lived with 6 different people. You don't even have simple layman testimony for this. You have experts. And, to say that the issue is the polyamory is just that's the red herring. It's not that. It's everything else. And you have to compare that to dad. That's why dad got the stability check mark. And then, there's the Moses v. King case that they cited. Well, in Moses v. King, the court held that there was no evidence of harm to the child. We have a different case here. This is a case where Dr. Levy is saying there is harm to the child. I mean, she screamed it. She said that Ivy was very affected, very much affected. And, I want to point out, Mr. King was, maybe still is, not really sure, married to Melody. Ariel is not married to Mr. King. what happens if Mr. King leaves? Because by all accounts, Ivy and Mr. King actually do have a pretty decent relationship. What happens if he leaves? That would be really bad for this child too. Like that is the instability that we're talking about. She needs to be with a stable family unit, which is what dad provides. Dad is the stable family unit, has been the stable family unit. What we're talking about here, as opposed to what was going on in Moses v. King, Moses v. King, the court said there was no evidence of harm to the child. Here we're saying this child was sleeping on the floor because of the instability in mom's house, that the child was harmed by the revolving door of caregivers, that the alienation and lack of communication from dad to mom is the issue that was harming the child. Dr. Levy testified that the child believes that mom and Mr. King can hear what she says about them.
Your Honor, I just want to make a standing objection to just the incorrect recitation to the court about what Dr. Levy has testified to. None of that was testified to. So I just want to make a standing objection just so I don't have to make it anymore, Judge. As you're muted, Judge.
I said you can, I don't know how you make a standing objection to someone's testimony that she's saying, because I don't, everything she says can't be incorrect. So I don't.
Okay, I just didn't want to keep interrupting.
Make the objection when it comes if you think that the facts are inconsistent. But I also want you to know that it is my intention to review her testimony anyway. Okay.
Yeah, I'm relying on my notes. Unfortunately, this was back in March, I think. So
Right.
I don't have
it was May. I thought it was March, but I think
maybe it was May when she did finally testify. And I do apologize if I am misstating it. It is not my intention. I'm going based on my notes, and I may have taken them down incorrectly. And for that, I am sincerely apologizing to the court and to opposing counsel.
Yeah, I'll take a look at it. Thank you. And along those lines, Ms. Marshall, if you'll come to my office. All right, go ahead and continue.
Yes, ma'am.
Okay, and then addressing the Todd v. Todd case that Ms. Ferry brought up, which is a good case. There needs to be more than living with a boyfriend to constitute a change of custody. But this, again, that is not what we're talking about. This isn't just living with a boyfriend, because if we did a change of custody for everyone who moved in with a boyfriend, y'all's dockets would be, from here, you would have a docket running from here to Fulton County and back. But that's not what this is about. There's a reason why we got a guardian involved, and there's a reason why we got Dr. Levy involved, because it's more than that. There's a lot more than that. It's the veil of secrecy. That is the issue. This case is about a child that has told her father after the divorce decree was entered that she's sleeping in a hallway. This case is about a child that is 4 years old with blisters on her feet from shoes that are too small, that are soiled. This case is about a child who's dropped off at 9:30 at night in the cold with no coat. This case is about a child who is sent to her father's home wearing 2-3 T3 underwear, and she's 6 years old. I mean, that's what this case is about. This isn't just about moving in with a boyfriend, and making it about Mr. King is really just, kind of mucking up the heart of this case. And it's a shame that we spend so much time talking about Mr. King, because he's really not the issue. He really isn't. The issue is that this child her best interests are simply not served at mom's house. And there are so many people who testified to that. Lowry v. Weiniger, if you can say that name better than I can, 340 Georgia Court of Appeals, 382. This case is actually really, really on point, and I would really ask the court to take a good hard look at this case. This is a case about mom concealing information from dad. So that is really the heart of this.
Say that one more time.
Lowry v. Weiniger, 340 Georgia Court of Appeals, 382. So this is a case where, like in this one, and, remember that video from back in May? Dad goes to this daycare, not in this case, but in our case. Dad goes to this daycare. He tries to get information from the daycare, and mom loops back around, comes back, and is telling this daycare worker, he doesn't need to worry about it. You give me the information and I'll give it to him. He doesn't need to worry. And dad was never, after all of this, daycare worker never had dad's information on file. And in the spot for dad's information was Mr. King. Dad never got the information from the daycare worker. And after the daycare worker was deposed, daycare worker stops talking to everyone. But look at that video closely. Mom is telling the daycare worker, don't even worry about him. I'm mom. I'm mom. You just communicate with me directly. That's exactly what was happening in Lowry. Mom was completely blocking dad out of decision making, blocking dad out of access to records. And, you know, they're under the statute, both parents have equal, if they have joint legal custody, they have equal access to records. So that is a violation of Georgia law, let alone the party's divorce decree. Miss King testified herself that she did have Mr. Maynard's full address the second time she enrolled Ivy in that daycare, but she didn't really need to put it on the record or on the forms because they already had the information and she just didn't feel like she needed to. I mean, she gave a really roundabout, again, cagey, evasive answer as to why dad's information wasn't on the form. That's what's going on in Lowry. And the court said no. Blocking dad's access or blocking the other parent's access to records is a material change of circumstance. It is because both parents, by Georgia law, have access. If they have joint legal custody, they have access to records. And if you are the type of parent who doesn't give the other parent access to records, that's a material change. And you, Your Honor, you can find that that is a substantial change in circumstance and you can award custody to the other parent. Same thing with Stanley v. Edwards, 363, Georgia Court of Appeals 331. Although the mother should have given the father notice of the events, if the information was not otherwise provided by the school, so I want to distinguish it, I'm sorry, from Stanley v. Edwards. So in this case, the mother should have given the information to the father from the school. But what was going on in Stanley was that it was clear from the record that the animosity between the parties had been ongoing throughout the relationship and began prior to the original decree being entered. That is actually not the case here. If you look at the messages between the parties, the animosity between them didn't really begin prior to, they actually had a pretty amicable separation. It wasn't until right before everything got signed that things sort of escalated when it was like, hey, but I really need to know where you're living. Hey, what is going on? But you can't, if you distinguish Stanley, if you distinguish our present case from Stanley, the present case could not have had the same kind of situation that they had in Stanley because the child wasn't in school at the time. So you can't say, okay, well, they've always had this kind of MO and mom has always excluded the dad from the child's school records because the kid wasn't in school at the time that they got a divorce. So you can't say, oh, well, the animosity had always existed, therefore it's not a change of circumstance. No, it is a change of circumstance because the child wasn't in school at that time. So briefly, because I do want to be done with this case and let you go, I just want to talk about the testimony and the credibility of it. Mom's testimony. She lied. She lied through her teeth. Her testimony was so inconsistent and so ridiculous. And to the point where, the guardian was even like, it did not jive with what I experienced. She, when she got up on the stand, her testimony, I mean, just look at the way she answered questions. She could not give a yes or no answer. Everything was cagey. And just in practice, if somebody answers a question with the word honestly, you can bet that they are not being honest. She told the guardian she knew about the murder conviction, but in the interrogatory responses, she put, sorry. She put that there were no convictions. If you look at those interrogatory responses, she listed the people that lived there and said no convictions. When we asked her about the record, she says, well, I don't really know, but it was nothing sexual. And it definitely didn't involve minors. It's like, well, if you know that it wasn't sexual and you know that it didn't involve minors, you must know at least something about it. But she didn't want to answer. She just didn't want to answer the question. And she was very cagey. And that is what the guardian testified to. She had a hard time getting information. She had a hard time scheduling. Dr. Levy even testified to the same thing. She tried to reschedule the appointments. She tried to reschedule, on multiple occasions. Mr. King was the one who dropped the child off. That Dr. Levy was concerned about that. She was very difficult to get a hold of. She put that Monique, whatever her name is, did live there on her interrogatory responses, but then she testified that she did not live there on the stand. I still, sitting here today on December 20th, nearly 2.5 years after this case has been filed, I am unclear to the exclusion of everyone on the planet who has lived there. I know with certainty of 6 people have lived there. I cannot exclude the rest of the people on this planet of who has not lived there. it's, you know, people just stored their things, but in the interrogatory responses, those people did live there. How is somebody confused about who did or did not live there? It's very simple. Did they go to sleep there? Did they close their eyes and then wake up again? It is not a difficult question. It really isn't. But the caginess and the lack of truthfulness, the lack of candor, that is the issue, Your Honor. Because if somebody is not being truthful about a simple question, such as who lives in the home, you can bet that they're not being truthful about the heavy-hitting questions, such as who is caring for your child. Is your child getting proper medical attention? Is your child doing well in school? Is your child attending school regularly? Those are the questions, the good questions that we didn't even bother to ask because we didn't think that we would get a proper answer on. And, you know, according to her own testimony, she just discovered that she's living with someone with a violent criminal history, although we know that not to be true based on the guardian's testimony. But you never even bothered to ask before you moved in with someone when you had an infant? According to your own testimony, you moved in with someone when you had an infant and you never even bothered to ask what type of person you were moving in with? Someone who was old enough to be your father. You didn't bother to ask? Not any way you cut it, it's not a good look. You know, she admitted that she had Mr. Maynard's address, but she didn't put it on file because it wasn't required. I don't know by who, but it wasn't required. She admitted that she knew the child, Ayedi, had been taken to the doctor for her feet multiple times, and she simply did not believe those doctors. She tries to put the blame on Mr. Maynard for her lifestyle. But is that really a credible position when she has known him to be in a monogamous relationship with her and one person, his current life? I mean, you know, she keeps saying like he's the one who introduced her to the polyamory. He's the one who introduced her to all this. But as far as we can tell, he's never been in a polyamorous relationship. There's been no testimony to that. He's only been with his wife since the separation. There's no testimony that has refuted that from anyone, but he's to blame for the polyamory. Okay. And then she tried to say that the blisters, literal blisters that we all saw pictures of on the feet were from a stub toe. That is the way she lies through her teeth in a way that like she believes it so fervently. Like, you know, she was straight faced telling you that's from a stub toe. I mean, the thing that is so alarming, Your Honor, that I think you should pay special attention to is that this whole family is so concerned that even her own father testified to say that nobody knew about his criminal record until they had a background check. Nobody knew about Mr. King's criminal record until they had a background check done. That Mr. King's testimony that he came over to the house and discussed it with the family was inaccurate. Nobody knew. The guardian testified that Mr. Ham was consistent about what he reported to the guardian about what Mr. King did, that he came in and out of the home, that she said that there were inconsistencies about breaking a jaw versus hitting in the face, but that what he said about the altercation that took place at the home, that was pretty consistent about what had been reported. You know, Ms. Ferry says that the overall collective evidence is that this didn't occur, but there are two people who testified about this. And he testified about it. And then the guardian ad litem testified that it was consistent. And then, you know, she's saying, well, they've all been in the same space. Yeah. Within the past few weeks after we received our trial notice, everyone's been in the same space. I've seen that happen a lot. His testimony makes sense too with everything else that has been going on. You know, Ms. King got into this relationship and then disappeared from everyone's lives, the family's lives. Then the next time, you know, she gets into this relationship, she's getting into this apartment, and then vanishes, right? That jives with what the guardian said, that jives with what Mr. Maynard testified to. And then the next time everyone sees him, there's an altercation and a confrontation that occurs, and then she disappears again. That jives. That makes sense because the issue is that everyone had
objecting to stating facts never put in evidence.
That's what the guardian had testified to, that she had a fractured relationship with her family.
That's fine. You can proceed. Like I said, I've already indicated what I was going to do. Go ahead.
Okay. So anyways, if you put all the testimony together and you put all the puzzle pieces together, you can put a timeline together as to what happened here, and it all makes sense. But you know, what is more plausible? That Miss King wanted a divorce and to transition to a polyamorous lifestyle and needed an excuse to get her religious parents on board. So she lies and tells them that she's being physically abused by Mr. Maynard, or that after years of marriage, a divorce, modification action, and the only person who can corroborate physical violence is Miss King. Or I'm so sorry. Let me restate that. Miss King is sitting here talking about how Mr. Maynard is a violent person. She accuses him of physical violence against her. She accuses him of physical violence against the child. She says that her dad had to show up to rescue him from, or rescue her from, I don't remember if she testified to that. Let me restate that. On cross-examination, Miss Barrie asked if Mr. Ham recalls picking Miss King up from Texas, where there's a hole in the wall and domestic violence incidents between Mr. Maynard and Miss King. And, you know, all of this, it's all a smokescreen, because what are you going to do, right? You want to leave a relationship and begin this polyamorous lifestyle, and you have very religious Jehovah's Witnesses parents. So what do? You can either say, I no longer want to be in this marriage and I want to go on to live a polyamorous lifestyle, which your Jehovah's Witnesses parents are not going to like, or you say he's physically abusing me, because that's an excuse your Jehovah's Witnesses parents might get behind. What makes more sense? And then she sticks to that excuse and tries to get this court to believe that this man is physically abusive to her and this minor child. That's what she has done. But no one has corroborated this. No one. Not a single additional witness, not a police officer, no reports, not Mr. King, not even her own father has corroborated that there has ever been any physical violence between Mr. Maynard and his child, or Mr. Maynard and Miss King. So I'm just going to end with this, Your Honor, because we have taken up a lot of this court's time, and I do sincerely, from the bottom of my heart, appreciate your patience and listening to all of this. Your Honor, you have everything you need. You have Dr. Levy, who testified this child didn't know her letters or numbers, but mom says she's doing first grade work, yet she's currently still in the first grade. What makes the most sense? That a professional child evaluator made a mistake about the child knowing age-appropriate material, or that mom lied about the child's abilities? That the school misplaced her currently in the first grade, or that mom lied to her attorney about the child's abilities? Additionally, Dr. Levy testified that the child thought that mom could hear what Ivy said about her and may develop an anxiety disorder. What makes the most sense? Do you think Dr. Levy doesn't know how to tell if a child knows her numbers and letters? You have everything you need. We have met our burden of proof. We have shown you a substantial change of circumstance. We have given you a court-appointed expert on 1993 in the form of the guardian ad litem. And that guardian ad litem gave you one more thing. She went and got you a forensic evaluator who went through and said the exact same thing. Both of them are saying this child should be with dad. The guardian ad litem has gone through. In fact, she said this child should be with dad immediately. She said immediately. I asked her, how would you like to see this effectuated? She said immediately. So please do what this dynamic little girl wants, because that's the other thing too, Your Honor. This is what this child wants. That's what the guardian testified to, and that's what Dr. Levy testified to. This is what this child wants. She wants to live with her dad. She is screaming it to anyone who will listen. I want to live with my dad. I want to live with my dad. I want to live with my dad. And you have it. Change of circumstance and best interest of the child. You've got it. You've got it right there. You have DERFAs on file. You can award child support based on the DERFAs. You can sign our proposed parenting plan, and you can make this exchange effective immediately. As for the contempt, you can find her in contempt or not. I don't think our client really cares at this point. If you do, we just ask that she be fined and that the fine be payable to DeKalb Legal Aid so that there can be some good done in the community. Thank you, Your Honor.
All right, thank you very much. I'm going to ask that you all return today. I'm going to finish reviewing some of the cases, and then I'm going to ask that you all return at 1 o'clock. No, because I'm not sure how long those the testimony was, and I need to. I'm going to review that. So. Let's make it 2:15. 2:15. Return today at 2:15. Same.
I'm sorry, Your Honor. May I give you a call, please?
Yeah, I know it's double booked, Ms. Marshall. I just need to review the stuff and roll. It should take me 15 minutes. Is that it?
No, ma'am.
That was something else?
Yes, ma'am, on this case.
Okay, well, come on over.
Yes, ma'am, thank you.
All
Do
right.
you want us to hold on, Ms.
Yeah,
Marshall?
hold for a second. Let me see what Miss Marshall is making me do. So give me a second. You know, she rules everything. So I've had an opportunity to go back and look at the video from Miss White's testimony and also Dr. Levy's testimony. So I know some of the issues that you all were kind of concerned about over the closing argument, and also the fact that it kind of spanned over days, essentially what the testimony was. At least you kind of rest assured that the court did go back. I had an opportunity to go back and review it. And then that's in conjunction with the court's notes, the detailed notes, as well as the summary notes. The summary notes are the ones that are kind of kept by the law clerk based upon our discussions after the case. And then, of course, my regular written notes. So although we were over several days starting in March, I've had an opportunity to review it. I think one of the main concerns that came across initially, and I think the court even kind of dealt with initially, was whether or not there was a material change in circumstances at first. That is I think we all agree that the court has to discuss that hurdle before we move forward on any other issues. And I think that was the request that Ms. Ferre made with regard to the court. And initially my thoughts were that I could clearly understand why she made the request, because it appeared that most of these things were already known prior to the divorce, particularly the environment of the mother. I went back and I looked at Ms. White's testimony. Her testimony is that they both agreed, Mr. Maynard and Ms. King, that the polyamorous relationship was known, that he was aware that Melanie King was living in the home. I'm not sure if it was Melanie King or Melanie King was living in the home at the time. And so the polyamorous relationship was known, and it cannot serve as the basis of material change. But I think Ms. Cricht, in her closing, even indicated that it's really specifically not that, but it's the kind of the concept of stability in the home that was more of the focus. But when I look at the actual complaint, the complaint on that issue, it doesn't talk about polyamorous relationship. The complaint just indicates that failed to provide information about who she was living with and the living arrangements to which the child is subjected. So the issue was the environment, or whether the environment created harm, and both Ms. White as well as Dr. Levy did not indicate that the environment created harm. I think that the main thing that kind of struck a chord with Dr. Levy, and quite frankly, the court, well, there are two things that kind of struck a note with the court as well. One is that Ivy has presented a situation wherein she is 5 years old, kind of living this very independent lifestyle, wherein she claims that she's kind of cooking for herself, doing her own homework, eating meals by herself, and basically is in an environment wherein she's doing a lot of self-care. And at 5 years old, that was alarming to Dr. Levy. And I remember even noting it in my own notes, it was alarming to the court as well. I appreciate, the independence, but I also kind of felt a little sad for her that she was eating meals by herself and that she felt like she was doing a lot by herself. And that that could have been one of the things that kind of supported her statement to both Dr. Levy and Ms. White that she wanted to live with Dad, because at Dad's house, it appeared to be a more nurturing relationship, a more nurturing home. She had her siblings with her. She didn't have to cook for herself. She didn't have to be by herself. Mr. Nain is clearly kind of dotes on her. You can clearly see that from his testimony and things that he's presented. And so that might have been the reason why she wanted to stay with her dad. And, obviously you can understand why that might, if in fact all of those, if that's correct, why she would choose to make that decision. But she's 6 years old, or at the time she was 5 years old. And so that is not the standard the court is looking at. I'm looking at the material change, and then of course the best interest standard. The other issues dealing with the medical neglect, there's some concern about her feet, and Ms. King, however, presented documents from her doctor indicating the child does not have the fungus. And this is her primary caretaker versus an urgent care person. So if I gave weight to that, I would give weight to her primary, and her primary doctor indicated that she is fine. And that was the medical documentation that she presented. I think that there needs to be some sort of discussion between mom and dad, and they need to come up with a plan that they're comfortable with in order to take care of her issue. And if sometimes you do things that you may not necessarily agree with, but if it allows for compromise, then you kind of do it. So if she needs to put on socks, you put the socks on, or just to have some sort of compromise in that situation, particularly if you have medical evidence that are contrary to each other. So in other words, what I'm trying to say is you have Mr. Maynard presenting evidence that the child has a fungus and has some issue. You have Ms. King presenting medical evidence to the contrary. And so you have two competing issues. How can one of them be medical neglect? It can't be. One is if you're following a medical advice for one, and another is following a medical advice, there can't be medical neglect because you're both following advice of your doctor. I think Ms. Crichton's position was there's a little bit more to this because the child is wearing too tight shoes and there's a blister that might be formed. But I just can't, there's just no part of the circumstance that I've heard where I would change custody based on a blister. I would say that there are some issues that they need to work with, and there are some things that she should take care of, but I'm not going to change custody based upon a blister. And then the other issue with the denial of visitation with regard to COVID. We were in COVID and everybody was making decisions related to their child during COVID. Again, it's a contempt issue, but I don't believe it's a material change of circumstances. Same thing with access to records. So I guess what I'm trying to say is I don't believe there's a material change of circumstances in this case. I do, however, and I would be remiss to or blind not to say that I appreciate and can understand and see that Mr. Maynard's home does appear to be a home where Ivy would thrive. And she apparently prefers to be there. I think that some of the concerns of stability probably would not be at issue in Mr. Maynard's home, but that's not for the court to say. The reason is, and I kind of thought about it long and hard, obviously. And it was even Ms. Crichton understands that you can't do modifications on these simple concepts because I would have modifications every week if someone decides to not give dad's address, and that's a modification, change of modification. It has to be something of significant substance that's going to change or be harmful for the child. Ivy was already living in an environment of a polyamorous relationship that was a part of the divorce. And even if dad was not aware of the full circumstances of it, he was aware of Mr. Maynard. He was well aware of Mr. King. And in fact, it appeared to cause a lot of discourse with her family because he was older and because they did some investigation. So it appeared to me that he would have been on notice that the family didn't care for Mr. Maynard as well, but there was a consent decree. And so I don't think that environment that is as an issue. And the environment, even though there could be a possibility of instability in the future, and I think that is something that might happen, but I can't deal with what might happen. Right now, she's been with Terrence since 2017. She's been with Terrence probably as long as Mr. Maynard has been with Alexa. That's based on what I heard, because I think Ms. Ariel King indicates that she left Texas, and at the time she wasn't sure, she wasn't aware that Alexa was in a relationship. She was 6 weeks pregnant, so that's probably 2016. 9 months later, she meets Mr. King. And then at some point, Mr. Maynard and Alexa start having this relationship together. So they've probably been together for about the same amount of time. And so the issue of stability there is kind of lost because of that. And they both can have relationships that go sour. Mr. Maynard's relationship can go sour. Ms. King's relationship can go sour. I do understand, and I think initially, I don't, we live in this environment, obviously, world is changing. Our concept of what constitutes family and, whether someone is in a heterosexual relationship or if someone's not, all of that, those things are changing. The court has to kind of move with those circumstances as well. And you don't hold your own personal concept of what you do or how you live your life in this environment. You look and see whether or not the child is harmed by the environment. And Dr. Levy indicates that despite the polyamorous relationship, she did not say that it was harmful to the child. I think she might have had some questions, but here's the deal. Even if Ms. King is in a relationship with Melanie King, I think maybe I-80 saw her kiss her or something of that nature. Taking the child and moving the child to dad does not alleviate the fact that Ms. King is involved in a relationship that is not heterosexual. She will be in her relationship regardless whether the child is with her on the weekends or not. So her relationship is her relationship. And I don't think there's anything that the court should do or can do or should do. I mean, Ms. King has made her decisions as to her lifestyle for her love relationship, and it is what it is. And no one has indicated to me that that's going to cause her mental or physical harm. In fact, like I said, I specifically asked both of them, and they specifically told me no. The only issue that they had was that there was this moving in and out of these relationships. Now, could that prove harmful later? Sure, it possibly can, but it's not proving harmful now. And the standard I have to look at is what's going on now. And right now, Ms. King has said Melanie moved on and there's no other person in their relationship. And so, of course, she needs to be mindful about who she brings in and out of the relationship. And if that became a revolving door, Mr. Maynard may have issues to come back and bring those issues to the court if they, in fact, are harmful to Ivy. But that's not what I'm dealing with right now. Same thing if Mr. Maynard started dating somebody else and other women and brought them in and out of the door. Ms. King might have some issues about that. So the environment, I don't think is harmful, and I do not think it is a nuke situation. I think the COVID issue was basically we have a situation that's kind of one-off, and I don't think it's enough to change custody, because during that COVID situation, we were getting hit left and right with parental issues because people had different ways of looking at things and how they were protecting their kids. For example, I got medical and I say the child is not going over there until everybody tests. And so, well, I have education and she needs to go to school. And there were so many people trying to deal with COVID and restraints of the system that were in place. And so it is not enough for me to make changes as a result of that. And then we got access to records. I do believe Ms. King's position was that at the time she enrolled IAV at the school, Mr. Maynard was not in the state. And at some point he did come, but she remained in the same school. I do think that Ms. King, I think at some point may have had some of dad's information, but she indicated she did not have all the information. And that's because I do believe they're both engaged in this thing where they don't want each other to be involved in what goes on at their household. In fact, their text message seemed to suggest that you do you at your house, I'll do me at my house, and we don't really need to get involved in each other's circumstances or situation. And so that's just how they live. Another thing that kind of caught the court off guard, but by the same token, it's just not the standard, and that is Mr. King. And what Ms. King knew about Mr. King and whether or not she put appropriate protectors on when she decided to have this relationship with Mr. King. Mr. King has this background that is alarming when you first hear. When you first hear the charge of having being convicted of homicide, at least, well, it sound like 2 counts. I don't know if it's 2 counts. They merge into each other or not. And even though the court kind of delved into it as much as I could, it's clear that there is a shroud of secrecy around his conviction and what he served time for and how he served it and how much information he gave to Ms. King and whether or not she was appropriate in trying to figure out what Mr. King was bringing into the relationship because she has a daughter and whether or not she should divulge that information. Now, I don't think Ms. King needed to divulge Mr. King's information to her parents, that she's a grown woman. And if she didn't want to tell her parents about his situation, I don't think she had to. But I do think Mr. Maynard, as the child's father, should be aware of certain things about who's going to be around the child, particularly when you decided to be involved in a stable relationship, like this is the person I'm gonna spend a considerable amount of time with. If we're talking about, a theft conviction, probably, all right, you might not mention it. We're talking about some embezzlement, maybe you don't mention it. You're talking about, a 30-year-old, possession of marijuana, maybe you don't mention it. But murder, child molestation, armed robbery, those kind of things you mention, because despite the fact that you might feel that there is a changed person, and hopefully you might be right about that, I think that you have to have some regard to the father being aware of those potential dangers that are presented with this child. And you cannot have those shrouds of, I'm not going to tell you the information. I just think you have a responsibility and a duty to say, here's the information. I have done my research on it. I am comfortable because of this. But trying to keep the information, I think, Ms. King, in certain circumstances you could have lost your child as a result, because you didn't appear to me that was willing to be forthcoming. I think you had a shroud of secrecy around that circumstances. I don't know why, particularly. Maybe it was because Mr. King didn't want his information all spread over records that involving a child that wasn't his. I imagine that's what it is. He said as much. And so he took a situation and said, I'm not divulging much, and I don't want you to divulge my information to him. Or your family, because that's not their business. Unfortunately, because you're in this situation, it is our business. And that's just where you are. You're in the middle of a contentious divorce or middle of a contentious battle for child custody, and you have to be open and honest, because when you're not, it causes people to have concerns about your household. So I think Ivy is thriving in school. There might be some concerns about what she's learning, what colors she knew, all of those things that Dr. Levy mentioned. But based on some of the things that the court has seen, I do think she is thriving in school, and that there's some appropriate discussions about her curriculum. And Ms. King is trying to make decisions to make sure that she is, for educational purposes, that she's being taken care of. I think there was some concerns about her bathing herself, that she had some soiled undergarments. I think those are things that could be taken care of with discussions. You can say, okay, Ivy came with soiled. I think you need to kind of go back over and refresh how she washes herself. And then Ms. King go, okay, let me figure that out. Okay, so Ivy, let's take a step back. Are you making sure you wash your butt every day or whatever? It's not things you just necessarily kind of take pictures of and say, I want to change custody. Like, that's something you work through. If a child comes and says, okay, her shoes are too tight, that's something you work through. Like, you buy a new pair of shoes, and you send them, and that bingo, that's done. Like, that's, to me, that's what I'm saying. Like, if my kid came to me and the shoes were too tight, I would just buy a couple of new pair of shoes, send them on over there, and just call that a day. I wouldn't try to have a situation where she comes back and I gotta watch her toes bleed. I just wouldn't. I just buy some new pair of shoes. So you guys got to start making decisions that reflect the idea that you're working together, and not make decisions that reflect the idea that you're ready for litigation. And that goes for both of you. So otherwise, you're gonna stay here, and instead of your college education fund, you're going to be paying attorney's fees, because you're not trying to work together, try to make sure that this just kind of works. And there are a couple of other things. Utilizing the child for commercial advertisement. I don't know what to do with that. I think generally, yeah, you might want to talk with dad about anything where the child is, being in a commercial or something of that nature. But again, I don't think it's a consideration for a change of custody. And if we're gonna, so I'll put a parameter in there about that everyone should give your address where the minor child is gonna live. That should take care of that issue moving forward as well. I think I wish that the parties, and I'm not sure exactly. I know at one point, Mr. Maynard, are you still in Columbus?
Yes, Your Honor.
Okay. Yeah, I mean, if you were closer, the court would certainly be very mindful and considerate of trying to give more visitation time, because she clearly enjoys being with her father. She clearly enjoys being with her brothers and sisters. She loves the attention Mr. Maynard gives her. And in consideration of that, honestly, outside of the standard that the court had to view, this might have been a tougher case for the court, like trying to determine what to do with her. But I said, when I look at the standard of modification, it would just be, okay, well, I think she likes it better over there, but that's not really the standard that the court has to look at. I got to look at what was the circumstances. Was there a material change in circumstances? And there's just not. But I do think that the child would definitely benefit from more time with the father, but your distance is too much for the court to consider anything else. That's the order of the court. Ms. Ferry, if you would prepare an order based on the court's position.
Yes, Your Honor, will do. Did the court want to speak to the reservation requested by respondent on attorney's fees, or what the court's position is on that?
Say that one more time.
Respondents requested to reserve to brief the issue of attorney's fees. Did the court have a position on that?
I mean, you can brief them if you want to. I mean, I can't prevent you from asking for attorney's fees, but I think I've already kind of articulated it. I think Mr. Maynard's position was well considered by the court. I think that he had a good reason for asking for what he was asking for. I just don't think it met the standard.
Understood, Judge.
But, I'm not stopping you from preparing or doing whatever you think is necessary. All right, that's the order of the court. Y'all are free to leave.
Thank you for your time.
Thank you. Y'all take care.